Hi, James Polk here with Apex Law Service. I want to talk about Fernandez v. California today. It's a case from 2014. It occurred in, I believe, 2009, the arrest. But a guy called the police. He said he was robbed at, I believe, gun and knife point, and he gave a description to the police. The police ran into the area after the guy ran off. And they found two eyewitnesses who said that, or two people who said that the suspect was hiding in a little apartment attached to a house off of an alley, I believe. And so they went there and knocked on the door. A woman came to the door and they asked if they could search, and then Fernandez pops out, not aggressively, violently pops out, but just kind of walks out and says, "No, I don't consent to a search." Well, so they arrest him and take him away, and then they ask the woman, "May we search the premises?" And she said yes. So they searched the house and found, I believe, a gun, a knife, gang paraphernalia. I don't think there was any drugs, but the issue was a Fourth Amendment issue that was argued all the way to the Supreme Court. Fernandez's attorneys tried to suppress the evidence that was found in the apartment, saying that he did not consent to a search, and so it was a split decision. I think it was 6-3, a 6-3 decision when it got to the Supreme Court to answer the question whether, if someone who initially protests or does not allow a Fourth Amendment, or I'm sorry, a warrantless search, leaves either willingly or by arrest, and it's just not there, if the other occupant of the house gives permission to police to search, is that evidence admissible because it isn't a violation of the Fourth Amendment. 6 of the justices said no, it is not a violation of the Fourth Amendment, and 3 of the justices in the dissent said that the police should have gotten a warrant. So that means that it is, as it stands right now, not a violation of the Fourth Amendment unless there's a new nuanced case or some type of case that overturns the law. That's one of those things. There's other cases about people in houses where one person controls one bedroom and one controls the other bedroom, basic roommate situations, and that's a little different. That's not what this was. This was, I think, a studio or a one-bedroom apartment. It wasn't like a double lease like that. So whoever has the authority to give law enforcement access to search every room of the house or any one room of the house, if they ever give it, as of now, it is admissible in court. The evidence that's found is admissible in court. So maybe some form of an argument can be made based on the logic of the dissent, but if the case law fits, the case law fits. So that's where the state of case law stands right now with respect to that issue. It's an interesting issue. Fernandez v. California. This is James Polk with Apex Law Service, signing off.